Good afternoon, and welcome to today's program, Access to Justice for Survivors of Sexual Harassment, Assault, and Misconduct. My name is Karen Woodard. I'm the Chief of the Employment Litigation Section in the Civil Rights Division at the Department of Justice, and I have the privilege of emceeing today's program. We are thrilled to be joined today by so many of our partners across the government and in the civil rights community. At the outset, I want to thank Assistant Attorney General for Civil Rights, Kristen Clarke, for spearheading today's program. I also want to thank Allison Randall and the Department's Office on Violence Against Women for partnering with the division to highlight the work the Civil Rights Division, OVW, and our federal and community partners are doing to combat sexual misconduct, whether in education, employment, housing, policing, or criminal justice matters. Today, you will hear from attorneys and other professionals from the Civil Rights Division, OVW, HUD, HHS, as well as advocates for survivors of sexual misconduct. And because it's an event about sexual misconduct, we're going to talk about actual cases. I want to let you know that some of the material is sensitive and could be upsetting. Our intent, of course, is not to be upsetting or insensitive. We know the gravity and impact of these cases. Those who engage in this conduct shatter lives with lasting and devastating consequences. Rather, our hope is to give you a better understanding of the work the department is doing to enforce the civil rights laws designed to protect vulnerable populations and the ways the department, the federal government, and advocates are working and collaborating together to uphold the Constitution and vindicate victims' and survivors' rights. Before we begin, I have a few housekeeping items to go over. First, we are using the chat function to make important announcements to participants. Please be sure to check the messages during today's program. Second, the audio and video functions for attendees will remain off for the duration of today's program. And lastly, this event is being recorded. A Privacy Act notice was included in the materials you were sent with your registration. And with that, we are ready to begin our program. To get us started today, we are honored to have opening remarks from Deputy Attorney General Lisa Monaco. Lisa O. Monaco is the 39th Deputy Attorney General of the United States. As a Deputy Attorney General, she is DOJ's second-ranking official and is responsible for the overall supervision of the department. A 15-year veteran of the Department of Justice and dedicated public servant, Deputy Attorney General Monaco has served as a career federal prosecutor and in several leadership positions across the department. She began her DOJ career as counsel to Attorney General Janet Reno, and went on to serve as an assistant United States attorney for the District of Columbia. And from 2013 to 2017, Deputy Attorney General Monaco was the Homeland Security and Counterterrorism Advisor to the President. She has also worked in private practice and taught national security law. Please welcome Deputy Attorney General Lisa O. Monaco.
Good afternoon, everyone. I'm pleased to welcome you to this event in observance of National Sexual Assault Awareness and Prevention Month. Thank you to Kristen Clarke, the Assistant Attorney General of our Civil Rights Division, to Allison Randall, the Principal Deputy Director of our Office on Violence Against Women, and the dedicated teams from both components for bringing us together for this important conversation. The department is committed to expanding access to justice for survivors, to holding perpetrators accountable, and strengthening our response to sexual assault and sexual harassment. We recently celebrated a major milestone in these efforts, the reauthorization of the Violence Against Women Act, or VAWA, which was signed into law by President Biden last month. I worked on the original VAWA legislation as a Senate staffer in the 1990s. That legislation, importantly, for the first time, among other things, recognized that sexual harassment, assault, and misconduct often go unreported. And even when they are reported, they're often met with doubt and disbelief, particularly for victims from marginalized communities. VAWA proved, though, that a law could make a real difference in people's lives, and it helped change the national conversation around sexual assault and domestic violence. We knew even then, however, that there was a lot more work to be done, and the new tools and resources included in this year's reauthorization are critical to modernizing our efforts to prevent and to end these crimes. That includes critical new tools to address sexual misconduct through our civil rights laws. Prior to VAWA's reauthorization, most sexual assaults committed under color of law were misdemeanors, punishable by less than 1 year in prison. And because these offenses disproportionately affect women, including transgender women, it left a large portion of the population without a way to fully vindicate their rights. VAWA brought parity also to sentencing by converting sexual assaults into felonies, subject to penalties commensurate with the egregious nature of the conduct. VAWA also closed a major loophole in federal law, making it a strict liability crime now for federal law enforcement officers to engage in sexual conduct with those in their custody. In other words, VAWA now codifies into law what should have always been obvious. There's no such thing as consent to sexual acts between federal officers and those held in their custody. During today's conversation, you'll hear more from Assistant Attorney General Clarke about how the changes in VAWA strengthen our ability to vindicate victims' rights, as well as about the important civil enforcement initiatives that the Civil Rights Division is pursuing in the workplace, in public education institutions, in housing complexes, and in state-run jails and other facilities. Of course, in addition to our work holding perpetrators accountable, the department also provides essential services that support healing and safety for survivors of sexual assault. Our Office on Violence Against Women provides critical funding for projects and programs that meaningfully and compassionately address sexual violence. OVW's Sexual Assault Services Program, for example, reaches every state and territory and supports rape crisis centers and other programs that provide services to survivors and their families. This funding is essential to provide sexual assault patients with the health care they need post-assault and to collect evidence of their sexual assault. During today's event, we look forward to sharing in more detail how OVW, the Civil Rights Division, and the entire Department of Justice is committed to redressing sexual harassment, assault, and misconduct. We're grateful that you've joined us for this important discussion. Thank you.
Thank you, Deputy Attorney General Monaco, for those opening remarks and for reminding us of the department's firm commitment to assisting victims and survivors of sexual misconduct. I now have the pleasure of introducing the Assistant Attorney General of the Civil Rights Division, Kristen Clarke. AAG Clarke currently leads DOJ's federal civil rights enforcement efforts. She is the first woman confirmed by the Senate to serve as Assistant Attorney General of the Civil Rights Division and has had a career dedicated to public service. AAG Clarke started her career right here in the division before joining the NAACP Legal Defense and Educational Fund and subsequently leading the Civil Rights Bureau of the New York State Attorney General's Office and the Lawyers Committee for Civil Rights under Law. Please join me in welcoming Assistant Attorney General Kristen Clarke.
I am honored to welcome you to today's program on access to justice for survivors of sexual harassment, assault, and misconduct. This is an especially timely and important topic as we honor both Sexual Assault Awareness and Prevention Month and National Crime Victims' Rights Week. The fight to end sexual misconduct, including gender-based violence, is more important now than ever. Nearly 5 years after the Me Too movement began, far too many people, and particularly women, still experience sexual misconduct in all facets of life. Combating sexual misconduct is a fundamental civil rights issue, and government agencies must be part of an intersectional, holistic approach with victims, survivors, and advocates to eliminate sexual misconduct root and branch. As you heard from Deputy Attorney General Lisa Monaco, combating gender-based violence and misconduct is a top priority for the Justice Department, including here in the Civil Rights Division. Since its inception in 1957, the Civil Rights Division's mission has been to uphold the civil and constitutional rights of everyone in the United States, especially the most vulnerable members of our society. Redressing sexual misconduct, which includes sexual harassment, sexual assault, and gender-based violence, is a core part of that mission. That's why it's essential that we continue to coordinate and strengthen our responses to these heinous acts. Today, you'll hear from the Civil Rights Division about our role in the fight to address sexual misconduct in our jurisdiction, both civil and criminal, over incidents of sexual misconduct and the civil rights laws that we use every day to vindicate the rights of survivors and to hold perpetrators of criminal acts accountable. To give you a sense of some of the impactful work that the Civil Rights Division has done in just the last few months, oftentimes in partnership with U.S. attorneys' offices around the country, I'd like to highlight just a few examples of some recent cases involving sexual misconduct. First, in the area of civil rights enforcement, the division partnered with the U.S. Attorney's Office for the District of New Jersey to bring a Fair Housing Act lawsuit against a landlord who owned hundreds of rental units in New Jersey. The landlord, Joseph Centani, sexually harassed and assaulted tenants and housing applicants for more than 15 years. Centani demanded sexual favors like oral sex to get or keep housing, offered housing benefits such as reduced rent in exchange for sexual favors, touched tenants and applicants in a way that was sexual and unwelcome, and made unwelcome sexual comments and advances to tenants and prospective tenants. He also initiated or threatened to take eviction action against tenants who refused his sexual advancements. In December of 2021, we reached a landmark settlement requiring the landlord to pay $4.5 million in monetary damages and a civil penalty, making this the largest monetary settlement the Justice Department has ever obtained in a case alleging sexual harassment in housing. In another case, we worked closely again with the U.S. Attorney's Office in New Jersey on an investigation into the only women's prison in the state. The investigation unfortunately revealed a pattern of failing to protect inmates from sexual abuse by staff. In August of 2021, we entered into a proposed consent decree with the state of New Jersey, whereby the New Jersey Department of Corrections agreed to implement comprehensive policies and practices to ensure that prisoners are protected from sexual abuse going forward. We've also addressed sexual misconduct in the education and employment context. For example, we partnered with the U.S. Attorney's Office in the Northern District of California to conduct a Title IX investigation into San Jose State University regarding its failure for more than a decade to respond adequately to reports of sexual harassment and assault of female student athletes by an athletic trainer, as well as related retaliation. In September of 2021, we reached an agreement that will improve the university's process for responding to complaints of sexual harassment and assault, and ensure that the university has effective Title IX training and prevention policies going forward. Notably, the agreement requires the university to pay $1.6 million to those students who were sexually harassed by the athletic trainer and who participated in the investigation. And prosecutors from the division and the U.S. Attorney's Office have since brought criminal civil rights charges against the athletic trainer. That case is still pending. The division has also partnered with the U.S. Attorney's Office for the Middle District of Tennessee in a Title VII lawsuit alleging that Cumberland County, Tennessee failed to take adequate precautions to prevent the former director of the county's solid waste department from sexually harassing nearly a dozen female employees. The unwelcome sexual advances and offensive remarks about the employees' bodies was reprehensible. We also uncovered evidence of unwanted sexual contact, kissing, and groping. In March of 2021, we reached a settlement with the county. They agreed to provide $1.1 million in compensatory damages to the women. They agreed to make revisions to their policies and procedures and provide mandatory training. The former director was also indicted on criminal charges. The Civil Rights Division's work also extends into the criminal enforcement arena. In addition to our human trafficking prosecutions, the division has witnessed sexual misconduct cases increase in number in the past decade. Specifically, we've brought criminal charges against road patrol officers, probation officers, corrections officers, and prison medical personnel who have committed abuse ranging from groping to rape at gunpoint. In one recent case, the division partnered with the FBI to conduct a comprehensive investigation and trial involving Eric Scott Kindley, a private prison transport officer who sexually assaulted more than a dozen women whom he was entrusted to transport all over the country. The trial ended with guilty verdicts, and in October 2021, the defendant was sentenced to 2 life sentences plus 5 years. One of the women listed in the indictment testified that when Kindley transported her from Alabama to Arizona in 2017, he stopped his van in a deserted area near Little Rock, purportedly to allow her to urinate. There, he sexually assaulted her while she was handcuffed, threatened her with a firearm, and reminded her, as he did other victims, that she was an inmate and transport and that no one would believe her if she reported what happened. We believed her. All of the perpetrators and entities in the civil and criminal cases that I highlighted today illustrate the breadth of jurisdiction the Civil Rights Division has over sexual misconduct. You'll hear more about some of these cases and other ones from attorneys across the division during today's program. I'm also pleased to announce today that the division has created a coordinating committee to combat sexual misconduct. This group will bring together staff from across the division who work to enforce the range of civil and criminal laws that prohibit sexual misconduct, including many of the people who you'll hear from today. And they will be charged with developing effective strategies to enhance and strengthen our efforts to combat sexual misconduct in all forms in the road ahead. The Civil Rights Division's enforcement work is just part of the holistic efforts needed to address and prevent sexual misconduct. The Justice Department also works to provide services to survivors of sexual misconduct, domestic violence, and other forms of sexual misconduct. This is why I'm so pleased that we partnered with the Office on Violence Against Women for this program. OVW is a critical partner in ensuring that survivors of sexual misconduct receive the social and economic support needed when these heinous acts occur. You'll hear from my colleague and friend, OVW's Principal Deputy Director, Allison Randall, as well as from representatives from other agencies committed to this work, including the Department of Health and Human Services and the Department of Housing and Urban Development. Of course, all of us in government know that we cannot and do not do this work alone. To be effective, we must partner and engage with impacted communities. And to that end, we're honored to feature, as part of our conversation today, 2 extraordinary advocates: Fatima Goss-Graves from the National Women's Law Center and Candicia Braid from the National Organization of Sisters of Color Ending Sexual Assault. They will provide critical perspectives from their work with and on behalf of survivors. We hope today's program provides important information about efforts taking place within the Department of Justice and across the federal government to address sexual misconduct, as well as the critical work that is being done by our partners in the advocacy community. We look forward to working with you to ensure that we can continue delivering on our strong commitment to prevent and redress these terrible and tragic acts when they happen in our communities. Today's event marks the beginning of renewed efforts to combat sexual misconduct, and we look forward to working with you all on these efforts moving forward. Thank you again for joining us today.
Thank you, AAG Clarke, for your remarks and for providing examples of the significant ways the division is addressing the issues of sexual harassment, assault, and gender-based violence. We appreciate your leadership on these issues. Now, we're excited to jump into our first panel of the day. We have a panel of attorneys from the Civil Rights Division who will provide information using real case examples about how the division uses its enforcement authorities in a coordinated manner to redress sexual misconduct. To give you some context, the division has both civil and criminal enforcement authority. It is divided into several sections depending on subject area. Today, you're going to hear from the criminal section and 4 sections that do civil enforcement work in the areas of housing, education, employment, and prison policing and institutional reform. This panel will be moderated by Special Litigation Counsel Farrah Gold, an attorney in the Civil Rights Division's criminal section. Farrah, the floor is yours.
Thank you, Karen. Hi, everyone. As Karen said, I'm Farrah Gold. I'm a federal prosecutor with the criminal section of DOJ Civil Rights Division, and I serve as our expert in prosecuting civil rights crimes involving sexual misconduct. For the next 40 minutes or so, we hope to give you a big picture overview of the division's work, both in the criminal and civil contexts regarding sexual misconduct in the civil rights arena. We, of course, can't do this work if we don't know about allegations or concerns, either from victims or survivors, or from those to whom they disclose, like so many of you watching. And so we hope that this information that we give you today will help you know when to contact the Civil Rights Division, because we may be able to prosecute the perpetrators, we may be able to hold institutions accountable, or we may otherwise be able to vindicate the victims or survivors' constitutional or statutory rights. And so we're going to talk to you about this using hypotheticals based on cases that we've brought. And as you'll see, the Justice Department, through the Civil Rights Division, has broad authority over incidents of sexual misconduct in a number of contexts and arenas. And you heard before, these include employment and education, housing, and the criminal justice system. And you should have received some materials today, and you'll see a handout that highlights some of the ways in which this division can redress sexual misconduct. So as we go through the hypos, I'm going to ask my colleagues with expertise in each area of the law to explain civil enforcement of the civil rights statutes that may apply. And I'm going to talk about the applicability of our criminal civil rights statutes. Before we dive in, I just want to give you one caveat. You're going to hear some of us refer to victims or survivors of sexual misconduct. I already did that. Karen did that before. You're also going to hear others of us refer to complainants, aggrieved persons, or charging parties. We're all just referring to those people on the receiving end of sexual misconduct. They're simply descriptors that we each use in our investigations. Of course, we're not making any judgments about anyone. So with that, let's get into it. And here on your screen, you should see the first hypothetical. According to media reports, a corrections officer in a state prison has been sexually assaulting incarcerated women for years. In fact, that prison appears to have a long history of sexual assault allegations against staff members, and there's barely, if any, investigation of those allegations. Okay, so the question is, what can federal civil rights laws do? So I'm going to start us off here and talk about criminal jurisdiction. I think we all kind of know that when a corrections officer, or anyone for that matter, commits sexual assault, it's a crime. It's probably a state crime. But here, even if it's a state corrections officer, it implicates federal criminal civil rights statutes. And that's because the federal government has jurisdiction to prosecute law enforcement officers and other government actors at all levels of government, state, tribal, federal, who commit sexual assault while acting under color of law. So I use the term color of law because that's what the statute says. It just means that the perpetrators are using their government authority to engage in the misconduct. So it has nothing to do with race or color, and we don't have to prove their conduct was motivated by any sort of bias or protected characteristic. That's for hate crime statutes, and I'm going to mention those a little bit later. But for this statute, where we use to prosecute government actors, when they use their authority to commit sexual assault, they violate the victim's constitutional rights. And so the statute is called deprivation of rights. We actually use the same statute to prosecute sexual assault by government actors as we do to prosecute unreasonable and excessive force by government actors. So you might know more about those excessive force cases and the sexual assault cases, because unfortunately, those are the cases we often see on the news all the time. But again, it can be used to prosecute sexual assault, and we use it that way. So when I say government actor, who is subject to this statute? Who can we prosecute? And so when I talk about it, I like to divide it into the obvious and the not so obvious categories. So who's in the obvious? Police officers, corrections officers, like right there in that hypothetical, probation officers, public officials. Well, who's in the not so obvious? You heard a little bit about this before from the AAG, prison personnel, not just the corrections officer like in the hypothetical, but it could be medical or nursing staff. For example, we just prosecuted a prison chaplain who entered a guilty plea for sexually assaulting a female who was incarcerated in that prison. It can be contract workers, government contract workers, like in private prisons that do a state function, perform a state function, or private prisoner transport officers. And you heard that big case that I was part of the trial team on, where we prosecuted the private prison transport officer who raped women during his transports. It can also be public school employees, be it state universities or like local high schools, again, like the athletic coach that the AAG mentioned, and I'll mention that again later. It can also be employees for government facilities. For example, my colleagues prosecuted a VA doctor, a Veterans Affairs doctor who sexually abused his patients. But the statute can also implicate the conduct of DHS detention facility employees or those who work in shelters that contract with the Department of Health and Human Services to house unaccompanied children from other countries. All these examples I just gave are government actors, government contractors who can act under color of law and are subject to prosecution if they commit sexual assault. And my colleagues and I have prosecuted all sorts of these cases with the obvious and the not so obvious defendants. And in fact, our sexual misconduct prosecutions, as you heard, have increased significantly throughout the last several years. Now, that doesn't necessarily mean that there's been an uptick in sex crimes committed by government actors. Rather, it likely means that we're learning more about them from talking to people like you, from raising awareness about the depth of our jurisdiction. And as a result, we've been able to hold more perpetrators accountable. We've been able to vindicate the rights of more victims. And we hope that we've been able to stop more vulnerable people from being victimized. But as much as we've made strides in our enforcement efforts, I really want to reemphasize what the Deputy Attorney General mentioned a little while ago. And I want to highlight for you what a really big deal the reauthorization of the Violence Against Women Act is for us. I cannot overstate how it is going to strengthen the prosecutions of civil rights crimes involving sexual misconduct. Because here's the thing, the statute that I just mentioned that we use to prosecute these cases, it was enacted with police brutality, not sexual assault in mind. And because it's not a per se sex crime statute, as you heard the Deputy Attorney General say, most sexual assaults committed under color of law are misdemeanors, absent us proving a specific statutory enhancement. So it's something like bodily injury might make it a felony, but most of us know who do this work that injury isn't often present in sex crimes. So for example, if an officer coerces his victim to submit to a sex act under threat of deportation or calling DCFS to take her kids away, it's a misdemeanor. Or if he pushes her up against his patrol vehicle and gropes her and puts his mouth on her breasts, it's a misdemeanor, all punishable by under 1 year in prison. Pretty outrageous, especially when you compare it to that same officer who unjustifiably punches a victim in the face and causes a black eye. That's a felony up to 10 years in prison. So this really illustrates the disparity in penalties, and it shows that government actors who commit sexual assault are subject to significantly less accountability than their counterparts who commit physical assault. But here's what the big difference that the Violence Against Women Act makes. Taking those examples that I just gave of those would-be misdemeanors, all of those examples of coerced sex and groping, well, VAWA has given us a statute that as of October 1st of 2022, this year, makes all of those examples felonies with potential penalties that are commensurate with the gravity of the crime. So it's a huge difference, and it will certainly allow us to better vindicate the rights of victims of those crimes, which disproportionately affect women and trans women. And remember, I said that our statute applies to perpetrators at all levels of government. Well, VAWA also gave us an entirely separate statute for federal law enforcement officers. And you heard the Deputy Attorney General mention, it's now going to be a strict liability crime. Consent is not a defense for any federal law enforcement officer to engage in sexual conduct with anyone in their custody or their supervision or under arrest or in detention. So I really just hope this kind of gives you a glimpse about why we are so excited in the Civil Rights Division about the reauthorization of the Violence Against Women Act and what a huge difference it's going to make in our ability to vindicate the constitutional rights of marginalized victims, and in so doing, finally adequately recognize sexual assault and gender-based violence as the civil rights issue that it is. But getting back to that hypothetical, my office has prosecuted several corrections officers for sexual assault, officers in tribal jails, in state prisons, and Federal Bureau of Prisons facilities. But that is not all that the Civil Rights Division can do with regard to that fact pattern. So I'm going to ask my colleague Laura Cowell, who is a deputy chief in the division's special litigation section, to weigh in. Laura, if you can tell everyone what the special litigation section is and what tools you have to affect positive institutional change in that state prison in the hypothetical.
Thank you, Farah. Yes, let me tell you about the special litigations work on the civil side and what we can do in a situation like that in the first hypothetical. The Special Litigation Section enforces the Civil Rights of Institutionalized Persons Act, also known as CRIPA, in state and local run jails and prisons, juvenile facilities, mental health facilities, nursing homes, and facilities for people with disabilities. CRIPA authorizes the Attorney General to investigate allegations that these institutions are subjecting people to a pattern or practice of unconstitutional conditions. That means systemic violations only. So one bad incident won't suffice, no matter how horrific. So talking about sexual abuse in correctional facilities, for example, in the hypo, where Farah's office is working to prosecute the corrections officer, the special litigation section would look into whether the prison has a pattern of failing to protect incarcerated persons from sexual abuse. We can do the same even if the perpetrators of sexual abuse were other corrections staff, like prison doctors, or if they were other incarcerated persons, as we are currently litigating in Alabama at the moment. Because even though the employees are not the ones committing sexual abuse, if the facility is not providing adequate supervision or a proper response to reports of abuse, the agency violates the Constitution by failing to provide reasonable safety for the people it incarcerates. In CRIPA, there are no damages and no individual plaintiffs. Our goal is to get injunctive relief to get the agency to fix the problems. For example, as Assistant Attorney General Clarke mentioned, we worked with the U.S. Attorney's Office for the District of New Jersey and opened an investigation into the only women's prison in New Jersey after 7 staff were criminally indicted by the state for sexual abuse of the women confined there, much like in the hypothetical. Ultimately, we concluded the state failed to protect incarcerated women from staff sexual abuse, and we identified all sorts of contributory systemic issues related to poor supervision, inadequate investigations, and retaliatory practices that discouraged incarcerated persons from reporting abuse. And as AAG Clarke mentioned, we resolved those concerns with a consent decree in August 2021.
So Laura, I wanted to ask you about the significance of those systemic issues. And I ask because in a lot of the prison sexual abuse prosecutions that I've handled, and my colleagues have handled, victims tell me they didn't want to report because they didn't think anyone would believe them, or they thought nothing would change even if they said anything. And they also knew that as a result of coming forward, they'd be put into segregation and lose privileges. And to them, coming forward and reporting was like a punishment. And so I wanted to ask you how that kind of information that you get from people who are incarcerated, how does that factor into your investigation and the remedies that you seek?
We all know incarcerated people are vulnerable, especially women with a history of trauma, and it is an abuse of power by officers who are supposed to be protecting them from harm to threaten segregation or to make them barter for necessities. No one should have to submit to sexual abuse to be able to visit with their children. So we work with the states to enter into agreements that require strong reporting and investigations, among other things, to ensure sexual safety for the people confined in these institutions.
And what if the failure to investigate doesn't happen in a prison, but instead if it's a police department? So it seems like from time to time, we hear about police departments failing to test a large volume of rape kits. I certainly see in our work, police departments declining to investigate sexual assault allegations because they make snap decisions about a victim's credibility without doing any more digging. Can the Civil Rights Division, what can you and your office do in particular about those situations with police departments?
So in addition to CRIPA, the Special Litigation Section also enforces, among other things, a statute that addresses law enforcement agencies' discrimination against women and their responses to sexual assault. In several matters, we found that law enforcement agencies conducted seriously deficient investigations of sexual assaults. These agencies' systemic failures to respond adequately to sexual assault has been due in part to law enforcement officers' reliance on gender stereotypes. For example, in our investigation of the Baltimore City Police Department, we found examples such as an email between a police officer and a prosecutor in which the prosecutor wrote about a woman who reported a sexual assault, stating, quote, "This victim seems like a conniving little whore," end quote, and pardon my language. The Baltimore police officer replied, quote, "LMAO, I feel the same," end quote. And in our investigation of the Missoula, Montana Police Department, we found instances like where a detective told a woman who reported a gang rape that it, quote, "was probably just a drunken night and a mistake," end quote. Our settlement agreements can remedy these types of problems by requiring adequate training and investigations to ensure gender bias does not undermine investigations and to ensure that procedures are trauma informed.
And thanks, Laura. I've been prosecuting sex crimes forever, it feels like, and those examples make me crazy. But the idea that you guys are doing this and instilling trauma-informed training makes me feel better and like we're making strides. So thank you for that. And so now, everyone, we're going to turn to the hypothetical number 2, and this one is divided into 2 parts. So we're going to talk about the first part first. And it's up on your screen. Multiple students at a state university report to campus officials that an athletic trainer has been groping their breasts and touching their groin or vaginal areas during massages and other treatments after gymnastics practice. Several of the student athletes have filed complaints with the school's Title IX office. So I mentioned before that the federal government has jurisdiction to prosecute state actors who commit and engage in sexual misconduct. That includes employees of public schools, including state universities. And it probably falls into that not so obvious category, but you know what? There is federal criminal jurisdiction to prosecute that athletic trainer, and we have one such case pending now. But there's also civil enforcement statutes that are implicated by the university's handling of those allegations. The mention of Title IX in the hypothetical was probably a clue for you. So discuss that first part of the hypothetical. I'm going to ask my colleague, Franny Cohn of the Civil Rights Division's Educational Opportunities section about that. Franny.
Thanks, Farah. Of course, there are civil rights statutes in the education context that we enforce when a school, like the one in the hypothetical, learns of sexual misconduct allegations and fails to take appropriate action. First, let me set the statutory conduct. Most relevant to today's conversation is Title IX of the Education Amendments of 1972 and Title IV of the Civil Rights Act of 1964. Title IX, of course, prohibits discrimination on the basis of sex in educational programs or activities of entities receiving federal funding. And programs and activities is very broadly defined under Title IX to include academics, extracurriculars, research, occupational training, or other educational programs or activities operated by a school that receives federal financial assistance, including notably athletics, like in the hypothetical. Title IV, on the other hand, the Civil Rights Act of 1964, another statute that gives us enforcement jurisdiction, protects students from sex discrimination in all public schools, including secondary and elementary K-12 schools, as well as public colleges and universities. And both of these laws, Title IX and Title IV, protect students from all forms of sex-based harassment, not just the groping that we saw in the hypothetical, but any kind of sex-based harassment. For example, we have many cases that we've brought concerning students who may experience sex-based harassment because they don't conform to the stereotypical notions of what masculinity or femininity means, or because of their sexual orientation or their gender identity. All individuals are protected against sex-based harassment, and that includes students, employees, or anyone else participating in a school's education program or activity. And sex-based harassment can be perpetrated by anyone, I should mention, including employees like the trainer in our hypothetical, students, or even third parties. So many of our matters, like the hypothetical, focus on a particular type of sex-based harassment, and that is sexual harassment, as in the hypothetical, which specifically includes unwelcome, objectively and subjectively offensive conduct of a sexual nature.
And Franny, we often hear about Title IX and schools having Title IX offices. Obviously, in that hypothetical, their Title IX program wasn't working so great. The Assistant Attorney General mentioned some of your colleagues' work at San Jose State University. The first part of the hypothetical is actually based on that case. And the results of that case really illustrate the significance of what DOJ and the division can do. Can you tell everyone about that investigation, please?
Yes, I would be very proud to. It was a case in which the section got a terrific result, and it illustrates our enforcement of Title IX in action. In that case, we partnered, as we often do, with the local U.S. Attorney's Office. In this case, the U.S. Attorney's Office for the Northern District of California. And our federal Title IX investigation focused on whether the university knew what was going on based on the complaints and other information that it received. And if it did know, what did the university do in response? After an investigation, we were able to reach an agreement with San Jose University, as some of the speakers have alluded to. And this agreement includes a wide program of institutional reforms, such as improvements in the university's Title IX procedures, the development of user-friendly information explaining how to report Title IX concerns, trainings for student athletes and trainings for athletics employees, such as the trainer in the hypothetical, and financial relief and supportive remedies for many of the athletes who experience sexual harassment. And we encourage you to check out our work, not just San Jose, but all of our Title IX work. But I've included a link to San Jose agreement in the chat.
Thanks,
Thank
Franny.
you.
Oh, and I do encourage everyone to read about that. And as I alluded to, we do have a pending criminal case against the athletic trainer for allegedly committing sexual assault under color of law. So now let's add some facts to that hypothetical about the university. So, and you'll see that come up on your screen. And here we go. In addition, female employees under the supervision of the trainer have been previously filed complaints against the trainer. There we go, stating that he had subjected them to similar conduct, including unwanted touching, sexual comments, and leering. One of the employees also alleged that the trainer reduced her hours after she would not have sex with him and fired her after she complained to campus officials. So I'm going to ask Kathy Sellers from the Employment Litigation Section to discuss how the division enforces Title VII of the Civil Rights Act of 1964. That prohibits employment discrimination. I'm going to ask Kathy also to talk about the remedies available to those employees in that second part of the hypothetical that I know appeared on your screen here and there. Kathy, please.
Yes, hi everyone. My office, the Employment Litigation Section, is responsible for enforcing Title VII against state and local government employers. As many of you know, there are two types of sexual harassment claims under Title VII. There's first what's called a hostile work environment claim. And this is where an employee faces unwelcome conduct of a sexual nature that's either sufficiently severe or pervasive enough that it creates an offensive and intimidating work environment for the employee. The second type of sexual harassment claim is what's called a quid pro quo claim. This is a little different. This is where a supervisor pressures a subordinate employee to perform sexual favors either in exchange for a job benefit like a promotion or to avoid incurring a job detriment like a demotion or a termination. Now, in our work in the employment litigation section, we see both types of sexual harassment claims, and both are present in the second hypothetical that Farah read for you earlier. There are two ways that the Department of Justice can bring cases under Title VII. The first is through individual charges of discrimination that are filed with the Equal Employment Opportunity Commission, or the EEOC. The second way that we can bring cases is that we have self-starting authority to investigate and litigate cases, even where there hasn't been a charge of discrimination filed with the EEOC, if we have reason to believe that an employer is engaged in ongoing pattern or practice of employment discrimination. And this can involve a pattern or practice of sexual harassment as well.
So Kathy, can you explain for everyone what you mean by self-starting authority? I understand that the EEOC can refer a complaint to you, and I hear self-starting authority, and I wanted to know if it's like when I read an allegation in the newspaper, or someone in the audience calls me and tells me about an allegation over which my office may have jurisdiction, and then I loop in the FBI and I say, hey, we need to investigate. Is it kind of a similar thing?
Yeah, it's definitely very similar. We gather information about potential pattern or practice investigations from a number of different sources, including news articles, or sometimes we learn directly from advocacy groups or stakeholders about a particular perceived pattern or practice. So, for example, putting into practice in the second hypothetical, we learned that the head trainer had sexually harassed multiple female employees as well as students at the university, and that his conduct included both sexual comments as well as physical touching. So if we had learned about the facts of this hypothetical through a news article, or if a stakeholder like many of you on this webinar had reached out to us directly and let us know that this trainer was harassing multiple female employees in this manner, it's certainly something we'd want to learn about in the employment litigation section. We would likely ask for more information, and we may be able to open a pattern or practice investigation to really make a determination whether this particular employer was engaged in a systemic violation of the law. And again, we can open those pattern or practice investigations without there being an EEOC charge. As part of the division's coordinated effort, we also likely partner with Franny's colleagues in the education section.
And that partnership is really a good reminder of how we can all kind of work across the Civil Rights Division, use all of our statutes to create positive institutional change. But I want to, Kathy, I want to switch gears a little bit. I know that combating workplace sexual harassment has been a long been a priority for your office. And so there's an initiative in place, and I'd like you to, if you can, explain to everyone the initiative in place to combat workplace sexual harassment.
Absolutely. In 2018, the employment litigation section, we implemented our own sexual harassment in the workplace initiative. And we began this initiative principally because we really wanted to commit more of the section's time and resources to finding creative ways of both addressing and preventing sexual harassment in the workplace. There are four major goals of our initiative. The first is that we'd really like to be able to identify and litigate more sexual harassment cases. Second, we'd like to promote best practices for preventing and addressing sexual harassment. Third, we'd like to conduct more outreach activities, including to stakeholder groups. And fourth, we'd really like to learn about more sexual harassment cases that are pending in the appellate courts and the district courts so that we can have the opportunity to weigh in and file amicus briefs or statements of interest. Since our initiative began in 2018, we've opened numerous sexual harassment pattern or practice investigations. We've also filed several significant sexual harassment cases. And through our cases, we've obtained millions of dollars in monetary damages for victims of the sexual harassment and have been able to obtain really significant injunctive relief.
Kathy, would you mind telling the audience about the Cumberland County case? I think that came out of the initiative.
Sure. And again, that case is reminiscent of the supervisor harassment that we saw in the second hypothetical, and AAG Clarke mentioned it earlier. In March of 2021, the employment litigation section and the U.S. Attorney's Office for the Middle District of Tennessee partnered and filed suit against Cumberland County. And we alleged through our suit that Cumberland County had violated Title VII because the director of their solid waste department had really egregiously sexually harassed 10 women that he supervised. Both the women he supervised were both employees, as well as some women who were assigned to perform community services at the solid waste plant as a condition of their probation. And the supervisor harassment, it included, I mean, it was extraordinarily egregious. It was everything under the sun. Sexually explicit comments. He exposed himself to women. He propositioned several of them for sex, and he would often corner women in remote areas of the plant where he would grope and sexually assault them. He would also tell his victims that he would fire them if they didn't submit to his harassment. And although we contended that the county did not have adequate complaint procedures in place, several of the women did find ways to complain to supervisory personnel, but the supervisors either didn't act on their complaints or they didn't forward them to higher management. And as AAG Clarke mentioned, we resolved that case through a consent decree that provided for $1.1 million in monetary damages for the victims of the harassment. And we were also able to get other broad-based injunctive relief, including requiring that the county hire its first ever human resources director.
Thanks, Kathy, for explaining all that. And that Cumberland case, as you know, also led to a civil rights criminal prosecution that is still pending right now. Probably in that not so obvious color block category that I talked about is the director of the solid waste department, who's alleged to have used his government authority to sexually assault those victims. So thank you, Kathy. And finally, last but not least, our third hypothetical. And that will come up on your screen in a second. In this hypothetical, a federal agency reached out to DOJ after hearing reports that a landlord was forcing housing applicants to perform sex acts on him in order to get apartments. It turns out that several more people made similar complaints to the local police department, and it is unclear what action the police department took in response to those complaints. So first, real quick, Laura, this sounds exactly like something your office might investigate in terms of discrimination in policing if the police department wasn't willing to investigate those complaints. But it also implicates the jurisdiction of the Fair Housing Act. And for that, I'm going to ask Erin Mee in Richmond to talk to you about that. Erin's the Sexual Harassment Counsel and Coordinator for the Housing and Civil Enforcement section. Erin, if you could please talk about the FHA and how it applies to sexual misconduct.
Sure. Thanks so much, Farah. So as Farah said, the department enforces the Fair Housing Act, and sexual misconduct can violate the Fair Housing Act, both civilly and criminally. The Fair Housing Act prohibits discrimination based on sex, and that includes sexual harassment. The Fair Housing Act covers a wide variety of housing, both public and private. So in addition to apartment buildings, it also covers, for example, single-family homes, condominiums, group homes, and under most circumstances, residential treatment facilities and homeless shelters. Typically, the victims in our cases are tenants and applicants who are female and single with young children. They are often especially vulnerable to this type of discriminatory treatment because they have limited housing options, they are financially unstable, and they may have a history of domestic violence, trauma, addiction, or homelessness. Applicants for housing benefits, or home loans can experience sexual harassment that violates the Fair Housing Act, even if they never moved into the housing and if they never obtained the housing benefits or home loan. So examples of behaviors that might indicate sexual harassment in housing include commenting on a housing applicant's body or looks, entering a tenant's home unannounced for no legitimate purpose, conditioning things like approving a home loan, renting an apartment, or making a repair on the victim engaging in sexual activities, and threatening to evict a tenant if he or she does not engage in sexual activities. Anyone who has control over housing can be liable under the Fair Housing Act. So owners, landlords, property managers, public housing employees, maintenance people, mortgage loan officers, they can all be defendants. And if the sexual harassment involves financing for a home, so for example, if a mortgage loan officer is harassing loan applicants, we can file under the Fair Housing Act and the Equal Credit Opportunity Act.
Thanks, Erin. And can you talk a little bit about the civil provisions of the FHA? But because you and I have talked so much about this in the sexual misconduct context, can you also mention the criminal provision that my office enforces?
Sure, of course. So the department can bring civil cases under the Fair Housing Act in two ways. First, we can investigate reports of discrimination and file civil actions against housing providers that engage in a pattern or practice of discrimination. Once we establish a pattern or practice of discrimination, we can obtain monetary relief for victims, even if the harassment they experienced happened several years ago. And we can also obtain injunctive relief and civil penalties. We also receive cases from HUD. So HUD has jurisdiction to investigate individual complaints. And when HUD finds cause to believe that the Fair Housing Act was violated, any party to that complaint can decide that a case should be filed in federal court. When that happens, those cases come to the department and we file a lawsuit in federal court. And as Farah said, her office, the criminal section of the Civil Rights Division, can bring criminal prosecution under the Fair Housing Act. That can happen if the sexual harassment involves force or threat of force, the harassment interferes with the person's housing rights, and if the conduct is committed because of a protected characteristic. Here, that would be sex.
Thanks, Erin. And you have that criminal jurisdiction under the Fair Housing Act down. And in fact, as the audience may know, and I mentioned a little bit before, there are several hate crime statutes that the criminal section enforces. And of course, there are times when hate crimes involve sexual assault, and so we prosecute those too. But I want to shift gears back a little bit. And Kathy talked about the employment initiative about sexual harassment. Can you talk about sexual harassment in housing and the initiative that you guys have in place?
Sure. So in 2017, the department launched a sexual harassment in housing initiative. We really wanted to dramatically increase our efforts to protect individuals from harassment by landlords and others with control over housing. Initially, our initiative focused on increasing awareness and reporting of sexual harassment in housing. And to that end, we partnered with U.S. attorneys' offices across the country and hosted over 40 roundtable discussions with local stakeholders about the Fair Housing Act, sexual harassment in housing, and DOJ's enforcement role. The response to that outreach was really tremendous. Since we launched our initiative in October of 2017, we have filed 23 cases alleging sexual harassment in housing, and we've obtained over $9.5 million for victims of that harassment.
And Erin, one of the cases that came out of that initiative was US v. Santani that the AAG mentioned in opening, and you worked on that case. Can you tell the audience a little bit about that and so they can see the FHA at work?
Yes. So this was a case that the Civil Rights Division and the U.S. Attorney's Office for the District of New Jersey partnered on really effectively. Joseph Santani was a New Jersey landlord who owned hundreds of rental units in and around Elizabeth, New Jersey. In December of 2021, he agreed to pay $4.5 million in damages and a civil penalty to resolve a Fair Housing Act case we had brought against him, alleging that he sexually harassed both tenants and applicants for over 15 years. The department opened our investigation of Santani in 2019 after receiving a referral from the Office of the Inspector General at HUD. Many, but not all of Mr. Santani's tenants participated in the Housing Choice Voucher Program, also known as Section 8. After making this referral, HUD OIG continued to offer tremendous support to the department on this matter. So under the terms of the settlement, Santani may never again own or manage rental properties. And in this case, the police did investigate the complaints about Santani, and we actually worked cooperatively with the local prosecutor's office as they continued to investigate him. And right now there are separate ongoing criminal prosecutions against Mr. Santani brought by the Office of the Union County, New Jersey prosecutor. To date, that office has charged Santani with coercing 20 tenants into sexual acts in exchange for financial relief.
Thanks, Erin. That Santani case, it was such a huge victory. You know, unfortunately, in my office, the criminal section can't take every case. And so when we can't, this is such a really great example of joining forces with local prosecutors to vindicate victims' rights in multiple ways. You also mentioned working with the U.S. Attorney's offices in the District of New Jersey, and Franny and Kathy and Laura also mentioned about partnering with the U.S. Attorney's offices. I just want to underscore for everyone that many of us partner with AUSAs from throughout the country. We're obviously all DOJ, we all enforce these statutes. Most of the cases that I and my colleagues prosecute are done in partnership with AUSAs. I just want to quickly round us out though and let you know about one other tool that we have to combat sexual misconduct. In addition to what I mentioned earlier about criminal prosecutions, I want to mention the Human Trafficking Prosecution Unit, which is housed within the criminal section. Many of you may know that human trafficking is the crime of compelling or coercing a person to provide labor or services, or coercing someone to perform a sex act in exchange for anything of value. My colleagues prosecute both forced labor and sex trafficking. It's not uncommon. Oh, it's probably more often than not, actually, that traffickers use sexual violence to gain compliance with those victims. So trafficking is a huge area where we see sexual violence, and we do what we can to redress those crimes. And talking about all of that is just in trafficking and everything else. These are all just egregious examples of sexual misconduct that, frankly, I think could be overwhelming if we just sit here and think about all the depravity and the inhumanity of it all. But the good news is that the Department of Justice has the tools to combat sexual misconduct, thanks to the civil and criminal civil rights jurisdiction that you heard about. We just gave you a lot of information in a really short period of time, just about 40 minutes. But we hope that now when you learn about sexual misconduct and you kind of hear these circumstances, that they sound like something we discussed, that you let us know about it. Because in so doing, you're going to be helping us to continue to strengthen our response to sexual harassment and sexual assault. So Erin and Kathy and Franny and Laura, thank you so much. Thank you to everyone for joining us. Karen, back to you.
Thank you, Farah. And thank you to our division panel for providing such meaningful insight into the coordinated work of the division in combating sexual misconduct across so many fronts. And as we continue to highlight the amazing work being done in this arena, I want to introduce our next panel. It's a spotlight on two advocates who are leading voices in working with survivors of sexual misconduct. To moderate this panel, I am pleased to introduce Melissa Milam from the division's criminal section, who will introduce our two powerful panelists. Melissa, the floor is yours.
Thank you, Karen. Hello, my name is Melissa Milam, and I am the Victim Witness Program Manager with the criminal section of the Department of Justice's Civil Rights Division. In this role, I work with survivors of human trafficking, hate crimes, and other criminal civil rights violations. I also provide training to Civil Rights Division attorneys on how to incorporate a victim-centered, trauma-informed approach to investigations, and to our criminal prosecutors on victims' rights under the Crime Victims' Rights Act. One of the most important aspects of my work is coordinating between law enforcement team of agents and prosecutors, the victims and witnesses, and the non-governmental organizations who provide shelter, counseling, healthcare, and other critical services to survivors of crime. It is my absolute honor to welcome Fatima Goss-Graves, President and CEO of the National Women's Law Center, and Condencia Braid, co-founder and strategic director of the National Organization of Sisters of Color Ending Sexual Assault, to join me to talk about their work in advocating for victims of sexual harassment, assault, and misconduct, and a discussion about what we, as the government agency that enforces civil rights laws, should know about helping survivors of sexual misconduct. I'd like to begin with asking Fatima the first question. Fatima, will you please share a brief overview of the work that the National Women's Law Center does to support survivors of sexual harassment, assault, and misconduct?
Sure, and Melissa, thank you so much for having me, and to the department for having this important conversation. And really, even in the very title of this event, we are hopeful that it assumes plans for future work, but it demonstrates that you understand the interconnectedness between harassment, sexual assault with other types of sexual misconduct, and the fact that they're all forms of gender-based violence. So thank you. So the National Women's Law Center is a multifaceted, multi-issue gender justice legal advocacy organization. And we confront the issues of harassment and gender-based violence in many different contexts, but with a focus on institutional responses. So we work on harassment in the workplace, in education, in healthcare, in the process for confirming judicial nominees and judges as a body of work, and more And in recent years, the Law Center had an opportunity to really deepen its work on harassment at work when we launched the Time's Up Legal Defense Fund and a broader legal network for gender equity after Me Too went viral. And I'm happy to talk more about the work we do with the Time's Up Legal Defense Fund and beyond, but our work is largely legal and policy work, but we also do direct work to support survivors, and we engage in public education and communication campaigns to support a broader public narrative that is in support of survivors.
Thank you for that, Fatima. Condencia, I'd now like to ask you, the core work of the National Organization of Sisters of Color Ending Sexual Assault is, quote, supporting and advocating for women of color with a goal of creating, quote, a world where sexual assault no longer exists and all women are able to live free lives. In your role as an advocate, what advice do you have for us, lawyers, prosecutors, investigators, and victim witness coordinators at the Department of Justice, about how best to support women of color who are survivors of sexual misconduct that we interact with in our enforcement work?
Absolutely. Melissa, may I talk a little bit about my organization as well?
Yes. I planned to ask you that in the following question, but yes, of course.
Okay, no problem. So CSAE as a national organization, we do a lot of work in relation to women of color and survivors of color as a whole. You know, one of the things that we are always remiss about is when we're talking about sexual assault, we are an anti-sexual assault organization. And one of the things I always like to remind folks that are working on issues of sexual harassment, sexual misconduct, and sexual assault is to be mindful in broadening your response beyond the legal context. Very happy to hear in some of the previous panels, folks talked about engaging across federal agencies, and that's a great thing. Because when we make sexual harassment just the legal context, we can make the survivor unseen and their trauma unaddressed. A person is violated and there's trauma related to that violation that needs support. As we know, sexual harassment is broad and the actions is a context of sexual assault. And we need to ensure support for victim survivors throughout the entire process that addresses the trauma that they have sustained as a result of the sexual assault, and often the re-traumatization going through the adjudication, enforcement process, and even after. And when we talk about women of color specifically, it's extremely important to see us and value our experiences. Recognize that we do feel pain and we can be victimized. Often for women of color, especially in Black and Brown communities, you know, Black and Brown women are not seen as victim survivors. Many women of color feel like we don't have the permission or the right to feel like a victim, that our pain doesn't matter. And so it's important that we recognize this, that we be recognized, and that women of color who are survivors be given the space to show up and show our pain in a way that it works for us. And especially when you think about working with women of color who are incarcerated, many of whom have suffered sexual assault even before they were incarcerated. Recognize that survivors may not be willing to come forward, or when they do, they may change their minds even having done so. We know that for women of color are disproportionately impacted by sexual assault. Yes, sexual assault can happen to anyone, but for women of color, we have often heightened vulnerability that are tied to the racism and pervasive sexism in this country that makes us a heightened vulnerability to sexual assault. As survivors, for survivors of color, we're also oftentimes dealing with so many issues that come up, that whether it be trying to economic issues, systemic concerns, engaging with family, trying to figure out how you're going to see your children, school, work, etc. The myriad of issues and systemic barriers. We need to recognize that survivors often can't separate that from whether or not they're going to address the sexual assault. And so yes, knowing that, unfortunately, far too many times, our story, our cases are not successfully adjudicated, we will think twice about whether we're going to engage with the system. And even when we do, survivors oftentimes may rethink and decide to move back and not continue going forward. Be recognized, be sensitive to all of these things that may be going on to survive with the survivor. And know that far too many survivors of color, unfortunately, feel that they're at a place where they need to say, because of so many issues, that the sexual assault, in the context of the sexual assault rather, that this too shall pass. Many women of color say we've dealt with worse, we've dealt with so many things, and we'll get through this. We need to make sure that we are consistent in saying to women of color, you don't have to get through this. And this is not something that you should have to deal with. Just two other things I want to say really quickly is to consider the role that you play in ensuring that survivors of color have support and access to services beyond the adjudication. And so thinking about what happens, after the fact, and what happens if you don't win the case, and thinking about safety and support during the case. What steps can you do to help survivors with safety? What steps can you help? How can you engage with other systems to ensure that they find a safe home, have economic sustainability, and are able to finish their education? I'm going to pause there, Melissa. Thank you.
Okay, thank you so much for that thoughtful response, Condencia. Fatima, I'm going to turn back to you. The National Women's Law Center advocates for gender justice, including around the issue of sexual harassment in education and the workplace. I would like to take those one at a time. First, employment. Are there specific survivor profiles where sexual harassment and misconduct is not being properly addressed? And what can the Civil Rights Division do to support those survivors?
So when we're thinking about harassment that occurs in the workplace, the thing that I think you all should be thinking about all the time is that retaliation typically accompanies complaints of harassment. And so what that means is that for some workers, the very idea of coming forward at all means risking your job entirely. And that's especially true when we're talking about workers who are in jobs that pay low wages or jobs that are shift jobs where the retaliation might look like giving you the terrible shift or not putting you on the schedule enough, not giving you the sort of hours that you need. And for workers in low paid jobs, or I would just add women of color more broadly, who are less likely to have savings and be able to take that initial blow of harassment. And within the Time's Up Legal Defense Fund intake over the last 4 years, we've received more than 5,700 requests for assistance. So we have a pretty good sample that we're able to look at, and 80% of the people who've come in that way said that they tried to use their internal systems and experienced retaliation. So for those who are doing this work, understanding that survivors are grappling with that as a part of whether to come forward in the first place is really important. The second thing I just wanted to really highlight for you all, and I'm sure you have seen some of this work, but we did an analysis of EEOC harassment charges that were filed between 2012 and 2016. And what we found was that Black women file sexual harassment charges at rates that are nearly 3 times that of white non-Hispanic women. And in the time of COVID, that has made all of these things worse, again, with concerns and worries about retaliation and losing jobs during an economic downturn. And so I hope you will think about that. I also hope you will think about the way in which these sets of issues line up with what we are seeing in the wake of the pandemic, where workers are actually coming together to demand change together. We saw the first strike for harassment, the first nationwide strike around harassment brought by McDonald's workers several years ago. And one of those cases recently settled, but there will be many more to come. But the drive for unionization that you may have been seeing in workplaces, primarily those that have a lot of low-wage workers, whether you're talking about what's happening in Starbucks or in Amazon warehouses or in retail stores, some of what's at the root of that is addressing, or the inability to address, forms of discrimination, including harassment. So I would think of those things as deeply related.
Thank you, Fatima. And before I turn back to Condencia, I just wanted to ask this second part of the question regarding sexual harassment in education. Fatima, can you tell us what supports do survivors of sexual misconduct in schools need? And are there certain survivor profiles who are not receiving those supports?
Yeah, I'm glad you were asking the question in that way. And I want to highlight, oftentimes when we're talking about sexual harassment and violence in education, there's a focus on what's happening in higher ed among college students or maybe grad students. But I want to start with what is experienced by those who are in K-12 schools and secondary schools. And one of the big challenges that you see there is that oftentimes schools don't really have systems in place for coming forward, systems in place for raising issues before they rise to the level of something more serious, and systems of accountability that allow for individuals to feel safe on the other side. You know, we've had cases where what has happened to the student who came forward is that they have found themselves on the other side of really rigid school disciplinary processes, because maybe they also violated a school rule, or maybe they engaged in some form of sexual contact. And in Georgia, which in particular has very rigid school laws around sexual contact in schools. And so one thing I would think about, especially for K-12 schools, is what is the context that these students are having to come forward with, and does it include retaliation as a matter of course for them to be able to express their issues? And what support do the school systems that may have not have been able to devote the same level of resources to the issue of harassment and violence that higher ed has? What support can the department, together with the Department of Education, be providing proactively to the adults in the building whose job is around creating a climate that is supportive for their students? And then the other thing that I will just name around what's happening in higher education, that so much of this is so deeply tied to the confusion over what schools' responsibilities are in real time. You all know that we are in litigation over the Title IX rule, but one of the effects of that is that there are some schools that have taken a very narrow approach in terms of their responsibility to address sexual violence that occurs in connection but not directly on campus, sexual harassment that is a thing that comes back and forth, where the student maybe doesn't actually, where the person engaging in the harassment doesn't actually attend the school, but the person who's experiencing harassment is experiencing it again and again. There are a range of steps that I think higher education institutions could be supportive to put in place, with the first order idea of creating this sort of climate where their students and their faculty can thrive. And if you keep that front in mind, you're more likely to have some success. And I would say, just the last point, that what we hear for students who are students of color, and Black students in particular, and for students with disability, they often feel like the systems that their schools have in place just aren't built for them, that they aren't spaces that they want to go, they aren't welcoming, and so some of the work that the department can be thinking about is, how does it provide proactive support to ensure that schools aren't replicating other harms in their efforts to address harassment and violence on campus?
Fatima, thank you so much. Condensi, I'm going to turn back to you. And we'd love to hear why you founded the National Organization of Sisters of Color Ending Sexual Assault and the work you do to support survivors of sexual assault.
Thanks, Melissa. So, it's a long story. And, the quick thing is that I think CSA was founded in a kitchen on a napkin, believe it or not. I think there's so much to tell, but in the time that we have, I think there's a couple of things I want to lift up. My co-founder, Luz Marquez, and I created CSA on the backs and with the power and might of an amazing group of women of color. CSA was created because women of color and communities of color working to address sexual assault, they said it was important for survivors and for the organizations that serve them to have a voice on the national level to ensure that the needs and realities of survivors of color are valued, represented, and heard. One of the most important work that we do is providing support, and we work to enhance the capacity of community-based, culture-specific organizations to provide direct services to survivors of sexual assault from communities of color. We are also very committed to having sexual assault seen as a public health issue. We really, as a country, as a movement, need to really do more to address the short and long-term impacts of sexual assault on survivors' physical and mental health. That is something that is extremely important. Throughout all of these cases, we oftentimes, we missed all of those long-term impacts for survivors. We also, one of the other things that CSA does is we engage in administrative and legislative advocacy to ensure that the voices and experiences of survivors are inform systems change and public policy. CSA is able to work in partnership with UJIMA, which is the National Center on Violence in the Lives of Black Women, on federal policy. And Melissa, I would be remiss if I didn't say I'm a little bit excited because we were able to get such exciting resources and access for communities of color, culture civic communities in the Violence Against Women Act. So I'm super excited about that. I do want to mention two things that we're even more excited about that will hopefully continue to move forward so much of what we talked about within the Department of Justice. We were able to, in the Violence Against Women Act, there's the creation of 2 new positions that will be throughout Department of Justice. One is a Deputy Assistant Attorney General on culturally specific communities in the Office of Justice Programs. The second is a Senior Policy Advisor for culturally specific communities in the Office on Violence Against Women. These positions is intended to coordinate federal policies, protocols, and guidelines on matters relating to culture civic communities. Among other things, these positions would work to address equity and inclusion for culture civic communities and survivors. Communities of color organizations and survivors, we want to ensure that our voices are heard throughout the department, that they're valued and they're reflected. And we look forward to working with the Office on Justice Programs and the Office on Violence Against Women to make sure that these positions are in place and we support their efforts. The last thing I will say is I mentioned a little bit that one of our important work is working with communities of color organizations, and I want to lift them up. Oftentimes, folks say to me, what do you mean by, you use the term culture civic communities and you use the term communities of color organizations. Culture civic communities are defined as communities of color organizations throughout legislation, and that's why we use the terms interchangeably often. And we also want to clarify that when we're talking about communities of color organizations, culture civic organizations, that we're talking about organizations that are created by and for the communities of color that they serve. It goes beyond being communities of color led. It goes to that these organizations are grounded and rooted in the culture civic community that they serve. They are lifelines of support for survivors of color, and they are uniquely situated to respond to the needs of survivors of sexual assault from culture civic communities. I cannot implore for the folks that are working throughout the Department of Justice, the enforcement, working on these issues, how important it is for you to be partnering with, engaging with communities of color organizations in the communities that you're working in. It is important. I get excited when I hear about, holding perpetrators and harm doers accountable. When I think about the cases of landlord abuse and sexual harassment, and I want to make sure that there are connections guidance to the culture-specific communities in those culture-specific organizations, rather, in those communities to support survivors in those communities, and also to be able to help lift up some of the concerns that they know, some of the issues of assault that are happening throughout their community that needs to be brought to attention of DOJ and the enforcement unit. I can go on and on, Melissa, but I'm going to stop there. I get excited talking about my communities, and I get excited about lifting up the needs of survivors. So I will stop.
Thank you, Condencia, and thank you, Fatima. I know that our time is too short, and I know that we have so much more that we can learn from both of you, but thank you again for joining me today and providing your insight and guidance on what we at the Civil Rights Division can be doing to support survivors of sexual harassment, assault, and misconduct while doing our enforcement work. Karen, back to you.
Thank you, Melissa, and thank you so much to Ms. Goss-Graves and Ms. Bray for taking time to be with us today. The work you do is so very important, and thank you for lending your powerful voices to this program. And now for our final panel, I am pleased to welcome and introduce Office on Violence Against Women Principal Deputy Director Allison Randall. Principal Deputy Director Randall is passionate about OVW's mission and meeting the needs of all survivors. And she has worked in the domestic violence and sexual assault field for over 20 years, including as Chief of Staff for OVW from 2012 to 2019. Please join me in giving a warm welcome to Principal Deputy Director Allison Randall, who will introduce our esteemed panelists from HHS, HUD, and OVW, and close out today's program. Allison, the floor is yours.
Thank you so much, Karen, and hello to everyone. For those of you who don't know the Office on Violence Against Women, OVW, we provide federal leadership and over $500 million in annual grants to administer justice for and strengthen services to survivors of sexual assault, domestic violence, dating violence, and stalking. And when we look at the progress that we have and haven't made since VAWA was first authorized in 1994, we can see that there are still disparities in how many survivors of sexual assault receive services and if survivors can access the justice that they seek. That's why OVW has incorporated sexual assault as a priority in many of our grant solicitations for this year, and it's an office-wide policy priority as well. Another key OVW priority is expanding economic justice and financial advocacy for survivors. Economic justice, including access to housing, is so necessary to support survivors, as you've been hearing, and research shows that increasing economic justice may even be a tool to prevent and end sexual violence. So to make this priority a reality for survivors, we're doing many things, but I'm proud to share that we've requested $8 million for a brand new direct financial assistance program in the fiscal year 2023 President's budget. So today we'll get just a snapshot of some of the ways that OVW and our federal partners at the Department of Housing and Urban Development and Health and Human Services are advancing economic justice and housing support to improve the safety and stability of sexual assault survivors and their families. So our first panelist is OVW's very own attorney advisor, Marnie Shields. Marnie plays a leading role in OVW's sexual assault work and our economic justice work. And she's been recognized across the department for her work on the Prison Rape Elimination Act and the National Protocol for Sexual Assault Medical Examinations. So Marnie, we've got two questions for you. The first one, can you speak to OVW efforts to keep survivors safe in the workplace? And as part of that, how can new resources secured in VAWA 2022, like enhanced access to legal services, improve economic outcomes for survivors of sexual assault?
Thanks, Allison. So to start with, the Violence Against Women Act of 2005 created a national resource center for workplace responses to domestic violence, dating violence, sexual assault, and stalking. And these are crimes that could be directly connected to the workplace. For example, if a person is sexually assaulted at work, but it could also take place completely outside of work, such as a person who is sexually assaulted by their landlord, but it still has an impact on the workplace. So this victim, the one who was assaulted by her landlord, might need leave for things like moving and seeking services like support groups, advocacy, medical care, or legal services. She might also need supports in the workplace. For example, she might want to change her phone number or email if the person who assaulted her has that information. And the trauma of having been assaulted might impact her performance at work. And so this National Resource Center is out there to help all kinds of workplaces in how to address these issues in a victim-centered way. They provide different tools and training and technical assistance. Their website is www.workplacesrespond, all one word, workplacesrespond.org. And I encourage everyone to check that out. We've also been working very closely with the Office of Personnel Management, looking at federal workplaces and how to improve the federal response. In the current administration, there's an executive order that we call the DEIA order, which is diversity, equity, access, and inclusion. And as part of that, federal agencies are required to examine their policies and update them so that the government can continue to serve as a model for the private sector. And we've been working closely, again, with the Office of Personnel Management to assist with that effort. And then to your point about VAWA, the newest reauthorization of 2022, one of the things it did is that it expanded the definition of victim services, so that where in the past, for our grant programs, if you wanted to do legal assistance, the statute for that program had to say legal assistance. And many of our programs had victim services, but not legal assistance. And so starting with next year, it will be both, so that any statute where it says victim services will include a full range of legal assistance. And as we know, these services can directly impact the economic well-being of victims, directly with things like employment law cases, but even also with things like housing, public benefits, and immigration cases that can really impact the economic stability of the victim. Also, the definition of legal services was expanded to include post-conviction relief. So meaning things like trying to get a record expunged if a victim is convicted as a result of their victimization. And having these convictions can preclude the victim from being able to get a job often. And so that new ability of the legal services providers to help victims with OPW funds, I think, will prove to be really critical.
Thanks so much, Marnie. It's crucial that we're protecting the rights of survivors of sexual assault everywhere, that we're increasing access to justice. And we know that incarcerated survivors of sexual assault face unique barriers to reporting and to accessing services. What can we do to address challenges for this vulnerable population?
So within DOJ, we have an internal working group with several different DOJ components called the Victims Behind the Walls Working Group. And the whole point of this working group is to look at those challenges you mentioned. So it could be things like logistical challenges within facilities of things like how can they allow victims to make calls in a confidential manner, given that the calls are all recorded. So just logistical things like that. And also a lot of issues around capacity of service providers to meet that need. And so one of the things that has come out of that working group is a new project that we just launched in partnership with the Bureau of Justice Assistance and the Office for Victims of Crime, where we've given an award to the Urban Institute along with some partner agencies, where they're looking at the possibility of a national service line for victims in corrections. And they're going to be developing a blueprint for such a line because we're really trying to do what we can to increase the capacity of services for that population.
Thank you so much, Marnie. Our next panelist is Shondell Dawson, and she is the director of the Family and Youth Services Bureau's Division of Family Violence Prevention and Services, the FIPSA office at the Department of Health and Human Services. Her office addresses domestic violence as a public health issue and strives to partner with the continuum of social service agencies to whom families often turn for help. Shondell is responsible for leading implementation of the Family Violence Prevention and Services Act. So Shondell, thanks for joining us. And within that context of health and human services and a public health framework, how is the Family Violence Prevention and Services Program protecting the rights of survivors of sexual assault, particularly at that intersection of housing and economic justice? What does a coordinated effort to address those issues across the federal government look like?
Those are all great questions. I want to thank you all very much for creating space for the FIPSA program to stand in partnership with our colleagues in the Department of Justice. None of our work would be possible without the strong partnership and leadership from the Office of Violence Against Women. And so I greatly appreciate the opportunity to be here with all of you today. To answer your question, for the FIPSA program and for survivors and the advocates that we support, as well as the sovereign nations that we partner with, safety means accessible, trauma-informed, and culture-specific services that focuses on connections to social services, to healthcare, to behavioral health, well-being, healing, and justice. I'm pleased to be a part of this discussion today to talk about how the FIPSA program's role has expanded to support sexual assault survivors and helping to ensure the continuity and accessibility of community-based social services, health services, and behavioral health services that survivors need to be able to heal. 2021 was a historic year for the FIPSA program. We received $1 billion in American Rescue Plan supplemental funding. And this exciting investment in ARP funding enabled us to administer $198 million in supplemental grants to support rape crisis centers and sexual assault programs across the country. These grants can assist states and territories and tribes and communities with the resources to expand services and support for sexual assault survivors, including virtual and remote services, emergency services, and expanded health and social service supports for survivors. The American Rescue Plan investment also included expanded services for culturally specific domestic violence and sexual assault community-based organizations with an investment of $49.5 million that allows us to support culture specific and community-based organizations and partnering together to meet the needs of survivors that have been impacted by COVID-19 and the public health emergency all across the country. This historic investment, coupled with the 38 years that the FIPSA program has been partnering with the Department of Health and Human Services and the Administration of Children and Families to strengthen the capacity of communities and tribes and healthcare programs and social service agencies to partner with local programs, to partner with advocates, to know more about the needs of survivors and strengthen their responses to violence, trauma, and abuse. This multi-decade approach has resulted in investments in improving systemic responses, increasing knowledge, and increasing community level coordination between social service agencies such as TANF and child support programs, as well as healthcare programs that are supported by our colleagues in HRSA, homeless service providers, early childhood programs, as well as Head Start agencies and victim service providers across the country. FIPSA's statutes and regulations provide very clear guidance on the expectation of broad accessibility of services, and we work to provide training and technical assistance and monitoring of our grantees to ensure that there's broad accessibility of those services nationally. This also means ensuring that we are providing a continuity of support on a state level through coalitions, as well as on a national level through resource centers and with tribes to be able to serve more than 1.3 million survivors annually. We leverage that knowledge and expertise to build partnerships strategically across the federal government to ensure that health and behavioral health services and social agencies and civil courts, for example, have the knowledge to recognize intimate partner violence and trauma and recognize its intersectionality, respond in ways that are supportive and equitable and in a trauma-informed manner, and are flexible to be able to support survivors' access to care and benefits. This has helped us to partner strategically with our colleagues in the Department of Housing and Urban Development, the Department of Justice, both the Office for Victims of Crime as well as the Office of Violence Against Women, to launch in 2015 the Safe Housing Partnerships Training and Technical Assistance Consortia. It was the first time that federal agencies had come together on that level and leveraged millions of dollars to think strategically about how we can increase knowledge and partnerships and awareness of policies and best practices around confidentiality and service accessibility for survivors of violence and trauma and abuse, and do so in a way that would support tribes and advocates and continuums of care, and knowing more about how to better critically address the needs of survivors and their children. We expanded our partnership to include the Sexual Violence National Resource Center with the support of a grant from the Office of Violence Against Women and funding from the Office of Victims of Crime. So our Safe Housing Partnership Continuum not only includes domestic violence experts as well as culture-specific programs that are focusing on tribes and sovereign nations, but is inclusive of those who know best about the needs of sexual assault survivors and can help guide training and technical assistance. We are grateful for the continuity of this partnership and are looking to continue to deepen and expand our work, our knowledge and expertise with communities so that they can think broadly about the needs of survivors, be responsive, and offer more continuity of comprehensive support. For example, we've deepened our work over the decades around access to services for the needs of survivors from racial and ethnic specific communities and communities of color, and have been lifting up what we have learned about racial inequality and other forms of bias and harassment that have impacted survivors from diverse and historically marginalized communities through our briefings, through our training, through our technical assistance, as well as with our resources that are available on our Safe Housing Partnerships website. The Safe Housing Partnerships federal partners are deeply committed to leveraging our knowledge and expertise to assist survivors experiencing homelessness, increasing access to housing services and support within communities, and helping to allocate resources in a way that is inclusive and built upon the needs and the lived experience of a diverse network of survivors all across the country. We are going to continue to expand our work, building upon the leadership of the Biden-Harris administration and learning more about how best to be flexible in our support. How else can we be more specific to the needs of survivors? And how can we keep pursuing broad accessibility for those who need it so that we can continue to ensure that survivors who are reaching out and seeking help in multiple ways can get that support when they need it at the time that they are asking for it, and is comprehensive to be able to help with their healing, help with their economic stability, and also help with their access to justice, how they may define that.
Thank you so much, Chandel. You are working on so many different levels with all of these different pieces. And, one of the things that you were flagging is that, we haven't always centered sexual violence, right? Like we started working on domestic violence, and now we've been, kind of weaving sexual assault in, and we have a lot of work to do, and these partnerships are incredibly helpful. So I'd love to bring in our next panelist, Carlo Ng, who is the Director of Gender-Based Violence Prevention and Equity in HUD's Office of the Secretary. And in this capacity, Carlo serves as a senior advisor on gender-based violence to Secretary Marcia Fudge and has an extensive background in advocating for survivors' housing protections, as well as providing national technical assistance and training on issues that are impacting the rights of survivors and immigrants in federal housing programs. So Carlo, I know this is something that you have been working on at HUD. Here at OVW, we continue to hear from survivors and from advocates that housing is one of the biggest needs for survivors of sexual assault, and that survivors struggle often to access housing that's free from discrimination and harassment. So, in our office at OVW, we're proud to fund a transitional housing program that focuses on holistic, survivor-centered approaches, and it connects survivors with permanent housing. But there's still so much work to do at this intersection, and I know HUD is leading the way. So can you describe the growing need for housing and homeless services for survivors of sexual assault? A little about the work you're doing and how VAWA 2022 could help address this?
Sure. Thanks so much, Allison. It's such an honor to be here with you all and to talk about these really important issues. Sexual assault is an often misunderstood issue in the housing context. So Allison, you mentioned the Violence Against Women Act, which provides housing protections for survivors of domestic violence, dating violence, sexual assault, and stalking. But often what we find is that for housing providers, when they talk about VAWA compliance, they're often talking about it from a domestic violence angle. And it's usually a very specific way of looking at domestic violence, where it involves only intimate partner violence between spouses and partners. And this typically doesn't include other types of family violence, such as violence between siblings, parents and children, grandparents and grandchildren, et cetera. So housing providers are very much often approaching gender-based violence situations with a domestic violence lens by, for example, mistakenly assuming that in order for a survivor to qualify for VAWA housing protections, the violence must be physical in nature and they have to happen in the home, both of which are not requirements that are part of VAWA. And so as many of you who are on the call today know, sexual assault and even domestic violence is much broader than that. Many sexual assault situations do not involve intimate partner violence or even violence between adults. Sexual assault can involve minors who are assaulted by friends, relatives, and community members. And in these situations, a parent of the minor may not be involved in the violence, but then the question becomes, what housing rights do the minor and their family have, and what remedies are available so that the minor and their family do not lose their housing assistance and they aren't facing homelessness because of the violence committed against the minor. And so how do we start to address these really complicated issues? And what I've found is that intentionality is extremely critical, especially when we're talking about addressing housing barriers for sexual assault survivors. As policymakers, we have to be very specific and intentional when we are developing policies and legal authorities that impact sexual assault survivors. And so I'm just going to share with you a couple of recent examples that we have involving our intentionality around addressing housing barriers for sexual assault survivors. So at HUD, we recently created an exception in our public housing and Section 8 program regulations so that parents and guardians who have custody of minors that are sexual assault survivors can maintain certain rights to access federal housing assistance programs, even if the offending parent or guardian owns real estate. Normally in these programs, if the family owns real estate that they are benefiting from, they cannot qualify for public housing or Section 8. And so as part of implementing this new rule, we included explicit language in the preamble of the Federal Register notice to make clear that the intention of the regulation was to protect the housing rights of sexual assault survivors who are minors. In another example, under the new Violence Against Women Act, the McKinney-Vento Act's definition of homeless for survivors has been revised to be more inclusive of the experience of sexual assault survivors. So now the focus is less on someone who is quote unquote fleeing or attempting to flee, which has often been interpreted by local providers to mean fleeing or attempting to flee a situation involving physical violence between intimate partners. And so with the change is a focus more on a survivor who faces homelessness because of the trauma they are experiencing as a result of sexual assault or domestic violence. And this revision is really interesting to me because I do think that it will force us as an agency to learn more about trauma, its different forms, and how that impacts housing solutions for survivors in different situations. And I'm really hoping that the definition change will lead to trainings and more education and outreach for continuums of care and other housing providers, and ultimately us seeing an increase for sexual assault survivors and accessing the many housing and homeless assistance programs and services that HUD funds. Other issues that we're looking into include examining HUD programs that have as an eligible population domestic violence, sexual assault, and trafficking survivors. So these include programs like the Emergency Housing Voucher Program that was created on the American Rescue Plan, the Home ARP Program, and the Domestic Violence Bonus Program. And making sure that as part of these programs, victim service providers across the board are involved in the implementation of the program so that survivors across the board can access the resources equitably. We're also working closely with the White House Gender Policy Council and other agencies to see how we can coordinate and collaborate to provide survivor-centered solutions. Because at the end of the day, if we are to truly help survivors, we have to meet survivors where they are at. And for us, that means creating policy solutions that are diverse, intersectional, flexible, and holistic. So we look forward to continuing our work with y'all in this space, with DOJ, HHS, and many of you on the call. And thank you again for having me here today.
Thanks, Carlo. We have just a couple minutes remaining, so would love to throw up into you, like what would be a key strategy to ensure that we are centering survivors, particularly survivors from historically marginalized communities, in our work? How are we ensuring that we're meeting survivors where they are? And Carlo, Chandel, feel free to pop in.
I'm happy to start first, and I'll keep it brief. I mean, it's very important for survivors to be involved in all of these conversations directly. Folks with lived experience have to be part of every decision-making process that we are involved in and any decisions that we make. And so that's one of the things that I'm hoping to do during my time at HUD, is to make sure that survivors are always part of the feedback loop that is always going back to HUD.
Thanks. Chandel?
The FIPSA programs work around partnering and lifting up the needs of survivors with lived experience from diverse and historically marginalized communities is in twofold. We are constantly working with the states and territories and tribes around broad accessibility of services for survivors, including language access and cultural relevant supports that has been embedded through the Family Violence Prevention and Services Act for decades. In addition to that, the American Rescue Plan has enabled us to expand our investment in programs that are built and led by culture-specific community-based organizations with deep knowledge of domestic violence and sexual assault. And so we are looking to not only expand resources for small community-based organizations, but continue to broaden our training and technical assistance to be inclusive of organizations that are leading and have deep knowledge of culturally relevant and culture-specific services and support. So for example, in 2021, we launched our first tribal safe housing capacity building center, right? So we are investing in the needs and services for American Indians and Alaska Natives experiencing violence and trauma and have housing needs. And we have also expanded our resource center on child protection and child custody. Is being led by a culturally specific organization, Caminar Latina, to provide national training and technical assistance about the intersection of domestic violence and child welfare and family courts for survivors. So we're thinking about our resources, our training, our technical assistance, our discretionary grants, but then also how we leverage that knowledge and expertise as we are partnering with our federal partners across the government.
Thank you so much. And I really want to thank everyone who's participated in one of the panels today or who joined our audience to commemorate Sexual Assault Awareness and Prevention Month and National Crime Victims' Rights Week. It was so inspiring to hear everything that the Departments of Justice, Health and Human Services, and Housing and Urban Development, not to mention our remarkable non-governmental partners, are doing to address and prevent sexual assault, misconduct, and harassment, and to provide necessary services to survivors. All of us at OVW were very excited to hear Assistant Attorney General Clarke announced the Civil Rights Division's new coordinating committee to combat sexual misconduct. And we cannot wait to see their innovative work in action and continue our partnerships. You know, you all in the audience know so well that sexual violence in all its forms is an affront to our values, impacting the lives of everyone in our communities, not just those of us who are survivors. Sexual assault harms all of us in a workplace or a neighborhood or a family. It ripples out, and it demands a response from all of us in a workplace or a neighborhood or a family. I was inspired to hear today about the many ways that our colleagues in DOJ's Civil Rights Division are at the forefront of that multifaceted response by enforcing the federal civil and criminal rights statutes in the workplace and in public education institutions, in housing complexes, in state-run jails, and more. And this is crucial. Sexual violence is community violence. Associate Attorney General Vanita Gupta captured this sentiment in a previous statement when she said, the impact of sexual assault can reverberate throughout a community, and the response to sexual assault within a community has a profound and lasting impact on the health and well-being of a sexual assault survivor. And, you know, as we've heard today, that response must be rooted in what survivors themselves tell us that they need. We must hold survivors at the forefront of our efforts to repair and prevent harm in schools and homes and workplaces. We know that sexual violence can and does happen to anyone in every walk of life, across the lifespan and gender continuum. That's why the Biden administration is taking a whole of government approach to addressing gender-based violence and is centering the needs of historically marginalized survivors at the core of that response. To prevent and end sexual assault and harassment, we must meaningfully advance racial and gender equity, including equity for transgender individuals. And we've heard a lot about that from our panelists today, and including the need to emphasize funding for culturally specific, community-based organizations and population-specific organizations. Organizations that are by and for communities of color, tribes, and underserved communities, because those organizations are more likely to understand the complex challenges, the lived reality for survivors when they're attempting to access services or attain justice, as well as being tapped into community resources and community resilience. And these organizations are thus often more capable of addressing and responding to the needs of survivors and meeting survivors where they are, as Carlos said. So increasing funding for these organizations is one of OVW's priorities, and it's also part of DOJ's racial equity plan. Well, as you heard from our panelists, housing for sexual assault survivors is a huge concern, particularly because they're underserved by traditional housing services and by our other responses. So that's why it's so important to ensure that survivors have access to housing that's free from discrimination, and why DOJ's Civil Rights Division Sexual Harassment and Housing Initiative is so crucial. VAWA 2022 expands housing stability for survivors by enhancing, not just housing assistance, not just housing protections, but also legal aid that can help reduce the risk of homelessness for survivors. And so this includes access to comprehensive legal representation in eviction cases, as well as post-conviction relief. And both of those can have a huge impact on survivors' ability to maintain stable housing. VAWA 2022 also increases, our ability across our programs to connect deeply and meaningfully to provide housing to all survivors. Because we know that when we keep people safe and housed, we impact entire families and communities, even generations. Well, we know that many of you in the audience are on the front lines doing this life-changing work, and it's an honor to be with you today. Thank you for sharing your time with us. Thank you for everything you do. You are key partners in combating sexual violence. And to all the survivors out there, please know that you are not alone. We see you, we hear you, we're with you. And together we can end sexual violence. Thank you everyone for joining us today.